Executive Order 14168 is the Trump administration's attempt to wholesale erase trans identity from the federal government. The landscape that transgender people are facing across the country. And in fact, the black with red striped states are those that are the most dangerous for transgender people, where their lives are most restricted by state law. Executive orders cannot and do not erase people's existence, right? Even if some of these policies do, or executive orders do not get challenged or overturned.
Welcome, and thank you all for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker, Carl Charles. Carl Charles is a senior attorney at Lambda Legal's Southern Regional Office in Atlanta, Georgia, where he litigates groundbreaking cases to expand and protect federal civil rights for transgender people. Most recently, he served as counsel in several major federal lawsuits, including BPJ versus West Virginia Board of Education, challenging a ban on transgender girls and women in school sports, Fain v. Crouch and Cadell v. Falwell, addressing discriminatory health coverage exclusions, Eller v. Prince George County Public Schools, representing a transgender teacher who was subjected to years of abuse, and many more. Beyond litigation, Carl also engages in policy and legislative advocacy for transgender rights. Prior to joining Lambda Legal, Carl served as a staff attorney with the LGBTQ Rights and Family Recognition Project at A Better Balance, where he advocated nationwide for LGBTQ inclusive family definitions in workplace laws and policies. He has also worked as a staff attorney with the New York City Commission on Human Rights Law Enforcement Bureau, investigating and prosecuting violations in New York City human rights law. The webinar presentation that you're about to watch will be approximately 1 hour, and time permitting, Carl will be taking questions from the audience at the end of the presentation. So if you have any questions that come up that you'd like him to answer at the end today, please go ahead and submit those by clicking the Q&A button in the control panel at the bottom of your screen. Now, without further ado, here is Carl to discuss navigating the legal landscape, recent developments in the LGBTQ+ rights.
Thank you so much, Nina, and good afternoon or good morning to everyone joining us here today. I'm very pleased to be here thanks to Justia, especially Nina and Arturo, who are helping with the broadcast today. My name again is Carl Charles. My pronouns are he, him, and I'm an attorney with Lambda Legal in our Southern Regional Office. So today I'll be discussing navigating the legal landscape, recent updates to LGBTQ+ rights. I will include in that discussion an overview of both the federal landscape and a brief overview, not entirely comprehensive, of the state legal landscape. So to kick things off, our discussion of the federal legal landscape will be quite robust. We've got executive orders to cover coming from the president, a variety of Supreme Court cases just handed down in June, not too long ago, and then some federal legislation that has been proposed by Congress and the Senate. So today I'll start by discussing presidential executive orders that were signed by President Trump in the first days of his new administration. So to begin, Executive Order 14168 is the Trump administration's attempt to wholesale erase trans identity from the federal government. And the administration, or I should say the executive order, has several different sections that take on this project. So first, and perhaps most comprehensively, Section 2 purports to define sex for all federal government purposes. Section 3 includes changes to federal identity documents, including passports, government employee IDs, and visas that the State Department issues. Section 3 covers, Section 3E covers removal of references to gender identity or transgender-related information from government websites, and also includes LGBTQ references as well. Section 4 directs the Federal Bureau of Prisons to change housing assignments for transgender inmates currently in federal custody. And Section 5 attempts to impose sex definitions on single-sex spaces in workplaces and other federally funded entities. So now, going a little bit more granularly into this executive order to explain both the provisions of the order as well as litigation that has been filed and is ongoing to challenge the president's executive orders and attempts to remove references to or other various protections that may have existed in the previous administration. So with regard to Section 3D, which changed the availability of transgender, non-binary, gender non-conforming, and intersex people to update the sex marker on their passports. So the State Department took action very swiftly after this executive order was signed, and within 3 days announced a policy change whereby X gender markers would no longer be provided to people in accordance with the policy under the Biden administration, which allowed for anyone who wanted an X gender marker on their passport to obtain one. So the State Department's actions immediately suspended that policy and also suspended any applications that were currently in process for gender marker changes. So that would be where someone needed to update their previous sex marker from, say, an F to an M or from an M to an F. The State Department then articulated within a few weeks thereafter the policy that sex assigned at birth would govern the issuance of people's markers on their federal passports. It's worth noting that the executive order actually had an incredibly narrower definition, and in fact, one that was scientifically unworkable. The executive order said that sex was defined at conception, which and based on a zygote's ability to produce a certain reproductive cell. And essentially, it's impossible to know what sex a person was designated at conception, since that's not how people's sex is designated. And you would need essentially a time machine and a microscope to figure out those details. So the State Department used a more common and frequently used and practice that we would argue is outdated, but that is the sex assigned at birth. So far, no one has been barred from traveling because of the sex marker on their passport, and notably, the State Department has not revoked any passports that are currently valid and unexpired, nor prevented any trans travelers from leaving or returning to the country. So litigation that is currently ongoing in response to this portion of this executive order, the ACLU filed a class action lawsuit in the District Court of Maryland. That case is called Orr versus Trump. This slide is a little bit outdated, but since actually the beginning of June, they have secured not only a class action that includes 2 classes of people, but the judge in their case has also expanded the preliminary injunction to both of those classes. The most current update as of last week or the week before is that the government has filed a motion to stay that preliminary injunction while they are appealing the court's grant of the class action and the PI. So the other case that is challenging the passport provision of this executive order is a Lambda Legal case, Schlachter versus United States Department of State, where Lambda Legal has challenged the passport policy on behalf of 7 individuals, several of whom are in, we filed this case in the District Court of Maryland, and a number of people live there in the District of Maryland, but we represent plaintiffs from across the country who have been either denied accurate passports or actually have been issued incorrect passports with sex markers that do not match who they are. So we filed that case on April 25th, and then filed a motion for preliminary injunction in the middle of May 15th, and we are currently awaiting the court's decision on that motion. But notably, again, we only represent 7 individuals. We don't represent the classes of people. We don't have a class action like the ACLU does. Okay. Executive Order 14168, Section 4. So talking about the same executive order, but now a different section. This was the part of the executive order that dictated to the Bureau of Prisons to change housing assignments for transgender people who are currently incarcerated in federal prison. Advocates learned that there were only 22 such people, and lawsuits were quickly filed challenging this policy by GLAAD Law and by the National Center for LGBTQ Rights and their pro bono partners. Those cases were filed very quickly after this executive order was signed, so filed January 26th, January 30th, and February 12th. And across those 3 lawsuits, 17 of the 22 transgender women in this situation are protected by a preliminary injunction. So those cases are continuing to move forward, but notably, it's a very small group of people who are impacted by that section of the executive order. Moving on to another executive order that impacts transgender people, Executive Order 14187, which is the Trump administration's attempt to ban medical care for trans youth through the executive power. The name of the executive order is listed there on the first bullet point. It threatens all federal funding to institutions that provide affirming medical care to patients age 19 and under. So initially, when this executive order was signed and publicized, just the language of the executive order caused many institutions to be concerned about their ability to continue to provide care, and indeed some briefly did stop providing care to patients under age 19. So that would include the provision of puberty blockers, hormones, and very, very infrequently, and mostly for older youth, occasionally top surgery. This portion of this executive order was challenged by a coalition of the ACLU and Lambda Legal in a case called PFLAG versus Trump, where we represent obviously PFLAG members, people who are parents of transgender young people who will be impacted by this executive order should it go into effect. The district court in Maryland granted a preliminary injunction against this executive order, and it was appealed by the government, and the Fourth Circuit held the case in abeyance until Scrimeti was decided by the Supreme Court, which we'll get to in just a few minutes, and which happened in the middle of June. So now PFLAG v. Trump is moving forward, and the court has requested briefing from the parties on the impact of Scrimeti on the PFLAG v. Trump case. So if folks are interested, please keep an eye out. There will be developments forthcoming. The next executive order related to specifically to trans rights is Executive Order 168. I think I have the numbers potentially wrong there. Actually, no, I'm sorry. This is the trans military service ban. It's also called prioritizing military excellence and readiness. Um, and this executive order, I will have to update this slide with the correct number. My apologies about that. It says that the adoption of a gender identity inconsistent with an individual's sex conflicts with a soldier's commitment to an honorable, truthful, and disciplined lifestyle, even in one's personal life. This is perhaps the most animus filled of all of the executive orders, although they all have language that uh, speaks in some manner disparagingly about transgender people. But this takes particular aim at the more than 12,000 active duty transgender service members who are honorably serving the United States and have been for many decades. And the allegations that to be transgender is dishonorable or dishonest tracks in stereotypes and tropes about transgender people that are offensive and inaccurate. The Department of Defense and the Coast Guard under DHS were directed to, within 60 days, change their policies on appointment, enlistment, induction, and retention to essentially make any person who has a diagnosis of gender dysphoria and is thereby transgender incompatible with military service. So very quickly, in early February, Lambda Legal filed a case, as did several other groups. Our case is Schilling versus Trump, which preliminary enjoined this policy nationwide, but the Department of Justice then moved for a stay of the injunction shortly thereafter, which was granted. And so now active duty service members are in the process of being separated. I will note that the United States military is technically the largest employer of transgender people because of how many trans people are and have been serving the United States honorably for many years. So unfortunately, without reaching the merits, the Supreme Court said that this policy could go into place. And so people are being removed from their jobs as we speak. Finally, Executive Order 14201, the ban on sports participation, in K through 12 and college athletics, titled Keeping Men Out of Women's Sports. This executive order attempts to dictate the definition of sex for the purposes of Title IX. It directs the Attorney General, Pam Bondi, to prioritize enforcement of the administration's interpretation of Title IX against trans-inclusive policies and programs. So people may have seen the President Trump got into a verbal disagreement with the governor of Maine because Maine has an inclusive athletics participation policy, and her retort to him was, "We'll see you in court," which they did see one another in court. This executive order directs all departments and agencies to review and rescind grant programs that do not comply with it. And there has been a very swift, unfortunately, public response to this executive order. So shortly after it was signed, the National Collegiate Athletics Association, the NCAA, immediately capitulated, even without any threat from the administration, and adopted an explicit no exceptions policy to the participation of trans athletes. The GLAD Law organization and the ACLU of New Hampshire expanded their existing suit on behalf of a trans young person in New Hampshire to include a challenge to this executive order. So if this particular executive order is of interest to you, there is at least one challenge happening out of New Hampshire. And then finally, Executive Order 14151 took on equity-related grants and programs. So the executive order is titled Ending Radical and Wasteful Government DEI Programs and Preferencing. And this executive order attempted to end or cancel grants or programs that fell under the administration's definition of DEI or gender ideology. A preliminary injunction was issued in the National Association of Diversity Officers in Higher Ed versus Trump, but was stayed in the Fourth Circuit. And Lambda Legal has two cases challenging this executive order. The first, National Urban League versus Trump. We amended our complaint in late June. The PI was denied, unfortunately, in May. But in better news, our second case, San Francisco AIDS Foundation versus Trump, filed in the Northern District of California in late May. Not filed in late May. PI was filed in late May and was granted actually just a little more than a week ago. And the U.S. government was required to restore $6.2 million in cut funding to LGBTQ and HIV organizations, which is critical funding that had already been appropriated to them by Congress, and is great news for a lot of small organizations who provide critical health services to the LGBTQ plus and HIV/AIDS community across the country. So, in summary, it's important to note, despite the broad reach of many of these executive orders cannot and do not erase people's existence, right? Even if some of these policies do or executive orders do not get challenged or overturned, LGBTQ plus people still exist and are still living our lives in the best way we can in our communities across the United States. Executive orders don't change federal statutes or regulations. They don't change state law or policy. Importantly, for attorneys, they don't change professional standards or professional ethics requirement or alter attorneys' obligations to treat clients, colleagues, and I would add opposing counsel and the clients of opposing counsel with respect. So plenty to talk about here in the next segment of the federal legal landscape is the Supreme Court litigation in this last term. I will start with LW versus Scrimetti, also known as US versus Scrimetti. This was initiated by this case was initiated by Lambda Legal and the ACLU's LGBT and HIV project. And it was our challenge to the state of Tennessee's ban on medical care for trans youth. Pictured here, second from right, is Chase Strangio, a friend and colleague at the ACLU, who is the actually the co-director of the LGBT project. He was the first openly trans person to argue in the Supreme Court very historically on December 4th, 2024. So the crux of the case before the court was a challenge to this law, the text of which you can read there, which I will not read now that you all can see my slides. But it challenged a prohibition on any medical care that would, quote, enable a minor to identify with a gender identity different from the sex they were assigned at birth, or attempt essentially to treat the gender dysphoria that a young person was documented to be experiencing. We won a preliminary injunction against the law in the district court in Tennessee. And shortly before we won that preliminary injunction, the DOJ under the Biden administration actually moved to intervene in the case as a party. And they were successful in doing so. So then moving forward, the defendants appealed the preliminary injunction to the Sixth Circuit Court of Appeals in the United States, joined us in that response. The Sixth Circuit Court of Appeals ruled for the defendants and found that rational basis was the standard by which Tennessee's law should be evaluated, that intermediate scrutiny did not apply, and actually held a number of other things in deciding the case. So in response to that opinion, both the plaintiffs, LW's parents representing LW, and the United States decided to petition the Supreme Court for review of the Sixth Circuit's decision. the Supreme Court granted the United States petition for writ of certiorari, and you can see the framing of the question there, whether the law SB 1 violates the Equal Protection Clause of the 14th Amendment. So that was the more narrow question that didn't deal with some of the other questions that the Sixth Circuit took it upon themselves to answer in reviewing the district court's ruling. So as I mentioned, June 18th of this year, the Supreme Court released their decision that Tennessee's law does not violate the Equal Protection Clause because it does not classify based on sex or trans status, but instead upon age and medical use, which is a permissible type of discrimination subject to rational basis review. So major takeaways, obviously, equal protection analysis for state laws banning medical interventions for trans youth has changed. Notably, the court did not articulate any decision about whether heightened scrutiny applies to classifications explicitly based on transgender status, though if you read the concurring opinions from Justice Barrett and I believe is joined by Justice Alito and Thomas, they would have reached that question. But the majority opinion authored by Chief Justice Roberts did not. The court also did not address or said that the plaintiffs did not properly raise whether such laws impermissibly discriminated based on or were motivated by anti-trans animus. We, counsel for plaintiffs, believe we did properly raise those arguments, but nevertheless, the High Court has not issued a ruling on that particular question. And of course, the opinion is very explicitly limited to minors, people 18 and under, who were the purview of Tennessee's law. So the immediate term implications of Scrimeti, obviously the Tennessee law stays in place. Plaintiffs challenging similar laws in states with and raising equal protection claims obviously face a more challenging legal landscape. Some of you may be aware there are now more than 25 states with gender-affirming care bans in place, and many of which are being challenged, but obviously the plaintiffs in those cases now have more of an uphill battle. Notably, there have been some downstream ripple effects from Scrimeti. The Supreme Court granted, vacated, and remanded 3 Lambda Legal cases, and that's not to say anything of other cases that might have also been remanded, but these were the main focus of our work. So as Nina mentioned, cases I was involved with, Cato versus Fowle, that has been the petition for writ of certiorari in that case was granted, the judgment was vacated, and it was remanded to the Fourth Circuit to reassess and reconsider in light of Scrimeti. Same situation in Anderson v. Crouch, which was our challenge to a Medicaid exclusion. Which was a challenge to healthcare exclusions for West Virginia Medicaid participants. And then, interestingly and somewhat confusingly, also in our case, Fowler versus Stitt, which was a challenge to restrictions on updates to birth certificates in Oklahoma. That case was also, or a petition for writ of certiorari was also granted. The judgment of the 10th Circuit vacated, and the case remanded to the 10th Circuit for reconsideration in light of Scrimeti. I think that decision from the Supreme Court has us scratching our head a little bit, as it is not a case about medical care, though it does involve an equal protection claim for the clients in that matter. So short-term implications for states and defendants, obviously, they are all arguing in every case, whether it is related to healthcare or not, that Scrimeti has an impact. That's to be expected. That's what advocates do. But that's what we're seeing in many of the cases across the country, whether they deal with healthcare or not. Another big case from the Supreme Court impacting LGBTQ people and their families is Mahmoud versus Taylor. This case was brought by parents in a county in Maryland, challenging the school board's decision to remove an opt-out option of the use of some books and curriculum that dealt with LGBTQ themes, people, families, etc. The school district initially had the opt-out program, then removed it, and citing difficulties with children being out of school and other absenteeism problems, the parents sued. Their case was dismissed by the district court and by the Fourth Circuit. The Fourth Circuit notably wrote that mere exposure to views contrary to one's own religious beliefs does not necessarily constitute a cognizable burden on the free exercise of religion. So even though there was no circuit split on the issue and longstanding precedent, SCOTUS granted cert, and the question was whether parents can opt their elementary age children out of classroom instruction involving LGBTQ themes. The High Court held that yes, parents should be able to opt their children out of such curriculum, and hinged its decision on three factors that needed to be present in order for the parents to have succeeded in this case, which is that when the children are young, so the court noted, Justice Alito, writing for the majority, noted that children in this situation must be young. They must be mandatory, they must be required to be in attendance, and the material has been presented to them as right or normative. Those were the three factors in the view of the majority that resulted in this decision for the plaintiffs. Notably, the decision does not require or endorse the removal of LGBT inclusive books from libraries. But despite that, there is, of course, the danger that some schools will over comply with this decision, all right, out of a fear of litigation or parental complaints, that they will treat this decision as more expansive than it is. And notably in the dissent, the dissenters raised, I believe it was written by Justice Sotomayor or Justice Jackson, that this is a slippery slope to challenges to all kinds of public school curriculum. And of course, there's a long history of attempts to exclude children and young adults from public school curriculum on a variety of topics that parents have alleged violate their religious beliefs. So the Supreme Court sort of resuscitated or gave life to the application of Wisconsin versus Yoder, which was a decision regarding compulsory school attendance, and has now applied that to exposure to ideas at school. Another big Supreme Court decision from this term was Kennedy versus Braidwood Management. There, the court held, answering a very narrow question, whether members of preventative healthcare task force were superior or inferior officers. The court held that they were inferior officers. The plaintiffs had alleged that the preventative care no cost sharing mandate of the Affordable Care Act violated their religious beliefs by having to provide no cost sharing coverage for things like medication to prevent HIV, preventative health care for women and other pregnant people and their infant children, among other things. And the court said, no, these officers did not have to be appointed by the president and confirmed by the Senate. They are overseen as a body by the Secretary of Health and Human Services. And so that was essentially a temporary win for people living with HIV or at risk for HIV who rely on affordable medications to prevent that, and also over 100 million Americans who have benefited from the preventative care no cost sharing mandate of the ACA. This case will not be the final word on that issue. Secretary of Health and Human Services, Robert F. Kennedy, has already started to change the makeup of that task force and has said that they can decide whether recommendations are approved or not. So that will not be the end of that matter. Another case that is not LGBTQ specific, but will have implications for LGBTQ plaintiffs alleging employment discrimination is Ames versus Ohio Department of Youth Services, where a white heterosexual woman argued that she was denied a promotion and later removed from her position with the Ohio Department of Youth Services, while a less qualified LGBT employee was given the role she sought. The Sixth Circuit dismissed her case based on the heightened evidentiary standard. And so she, the plaintiff, challenged that standard was inconsistent with the text of Title VII, which essentially that standard means that people in majority groups, that is, people who are, either in a racial majority, a gender majority, sexual orientation majority, they had a higher standard to prove workplace discrimination. And in a rare unanimous decision, the High Court said 9-0, this standard is not consistent with the text of Title VII. So very quickly, the Supreme Court granted cert in a few key cases for the upcoming 2026 term. So very briefly, Childs versus Salazar, a challenge to Colorado's ban on conversion therapy. The court will be hearing arguments and briefing is occurring this fall. And then the Supreme Court also granted cert in 2 cases challenging state athletic bans on trans youth participation. Little versus Hecox, which is an ACLU case, and BPJ versus West Virginia State Board of Ed, which is an ACLU Lambda Legal collaboration. There are case facts there you can take a look at, but those cases both will be addressing this question here, and oral argument is scheduled for the January 2026 term. So now moving on to federal legislation. A variety of laws, bills impacting the LGBTQ community were proposed during Congress's session this spring. There were 50 bills introduced as of early June, and 40 of those 50 bills introduced in Congress or the Senate explicitly targeted transgender people. This is actually a fewer amount of total bills as compared to 2024, which is probably due to the executive orders and the change in administration. And you can see the breakdown of those bills and the topics they address, with the largest majority of the bills targeting healthcare bans in some form or fashion, followed not so closely by bans on athletics participation. Notably, the federal trans sports ban was unsuccessful. SB 9, the Protection of Women and Girls in Sports Act, it passed the House by a slim majority, but failed to secure 60 votes in the Senate. I'm going to kind of skip over this slide because this provision that I'm going to mention was actually removed from the final tax and spending bill that did pass and I believe was recently signed by President Trump. But there was, in June, there was a provision that would have cut all Medicaid coverage for transgender people in federal Medicaid dollars, which then, of course, is given to the states. And so I just want to highlight for people that in 2022, there were almost 300,000 trans adults enrolled in Medicaid. LGBT adults in general are twice as likely as non-LGBT adults to have Medicaid as their primary insurance. That is obviously a product of discrimination that results in LGBTQ people being underemployed and more reliant on state services. But of course, of that group, cuts to Medicaid will most severely impact transgender people. Moving on to the state legal landscape, I'll touch briefly on state legislation and state court litigation. So starting first with state legislation, there was, again, a record number of anti-LGBTQ bills introduced in 49 state legislatures in 2025. You can see again the breakdown in the subject matter of these bills in the graphics on the right-hand side of the slide. Healthcare ban bills are the highest in number at 139, actually followed quite closely by bans on K through 12 or collegiate athletic participation. So the total number of bills obviously approaching 900. This figure was actually from early June. So most state legislatures were wrapping up their sessions or had already ended by late May, early June, but a few states continue to go through the summer. So I do just want to flag that this is not the most updated figure. The total bill count might be higher. I think it's worth pointing out that in 2020, there were just over 100 total bills aimed at constraining LGBTQ people's lives in some form or fashion. So in 5 years, there has been, what would that be? Essentially an 800% increase in the number of bills introduced by state legislatures targeting LGBTQ people. Perhaps again, unsurprisingly, 80% of the bills this year targeted gender identity or transgender status in some form or fashion. So as of late May, early June, of those 867 bills introduced, 518 have failed. 98, right, have passed. So compare that 5 years ago, only 100 total bills, only 100 total anti-LGBTQ bills were even proposed. And now 5 years later, we have that many bills passing. So that's a really stark difference. Of those, 13 of the 867 were vetoed by state governors. And again, this count was last updated in late May, early June. There were 85 bills enacted. And so likely of the 98 passed, or I should say of the total bills, there will be more that have passed, likely not by many. As I said, many state legislatures wrap up in late May and early June, and there are likely to be a few more that have been enacted. So to the right here is a graphic from Erin Reed. She's a trans journalist who tracks anti-trans bills across the states, and she produces an anti-trans legislative risk assessment map. I've included a link to her website there so that she is properly attributed for this graphic, but it helps give you a visual understanding of the landscape that transgender people are facing across the country. To the extent that you weren't aware of it already, or maybe you're thinking about it as I'm, talking about the numbers, but you can really get the sense from this concrete, differently colored map here, right? Where the blue and light blue states are those that maintain protections and inclusive policies for trans people, and the red and very dark red states, and in fact, the black with red striped states are those that are the most dangerous for transgender people, where their lives are most restricted by state law. So then, by state count, 21 states have passed new anti-LGBTQ laws, some of which, as I mentioned, are already in effect or go into effect later this year. The states with the highest number, notably Montana and Idaho at 11, followed by Wyoming with 8, Arkansas with 7, and Utah also with 7. But as you can see, there's a fair distribution across many states in the Southeast, Midwest, and a little bit in the West as well. So again, I won't read all of these bills to you, but I wanted the audience to get a sense of the various ways that the states with the most bills that have passed, just how detailed they have been in restricting transgender and in some cases LGBTQ people's lives through state law passage. So Idaho, you can see they've got a sports ban resolution which expands their existing trans athletes sports participation ban. They have healthcare restrictions. They're making changes to what can happen in public schools. They are also doing various things that impact parents' rights. parents of LGBTQ youth, and similarly, that is the case in Montana as well. So, restroom bans in both states in government buildings, bans on the LGBT flag being flown, sexual orientation and gender identity curriculum bans, and other restrictions that target LGBTQ people's existence in really specific ways, right? Looking at the criminal grooming bill in Montana, the anti-trans child custody amendments, which basically ignore a parent who wants to affirm their child's expressed and documented gender identity in favor of the parent who does not want to do that. Monetary penalties for discrimination is not a good thing. That's actually quite the opposite. It is going to penalize people who do things in support of LGBTQ people in certain circumstances. Similarly, Wyoming, Utah, and Arkansas, again, generally the same flavor of laws. Sports bans, restroom bans, healthcare bans, and limitations on expressions of LGBTQ allyship or support as documented through waving of pride flags or expressions of LGBTQ inclusion in public schools. So I think it's important to note for the audience here that state laws obviously are incredibly important. More LGBTQ adults live in the Southeast than any other region. When I share that with various audiences, that surprises people. And I think that's because you can sometimes get the idea from media or from news media and popular media that a lot of, or the majority of LGBTQ people live in major metropolitan areas on the West or the East Coast, aka San Francisco, New York City. There are certainly large concentrations of LGBTQ people there, but there are LGBTQ people everywhere in the United States. And perhaps that is a redundant and unnecessary statement for many of you attending this webinar, but I do think it's important to emphasize the data to support that statement. This was pulled from the Williams Institute out of the UCLA School of Law. They do a lot of the data and research related to LGBTQ populations across the United States. So, thinking about the map we just covered and the limitations and restrictions on particularly transgender people, but also LGBTQ people, it's worth noting then that more than half of the LGBT population live in the Midwest and the South, including 2.9 million in the Midwest and 5 million in the South. And so if you map on the anti-LGBTQ law map to where LGBTQ people in majority live, you're seeing the most restrictive laws impacting the majority of LGBTQ people. And so I think this last bullet point is really crucial. Less than 1 in 5 LGBT people live in the Northeast, right? Where there might be a confluence of inclusive, supportive laws and policies. So another figure there to help underscore the point I just made, looking at the West, the East, the Midwest, and of course the Southeast, right? Which includes all the way as far west as Texas, as far north as Virginia, West Virginia, and Maryland. And obviously the highest number is going to be in the Southeast and into the Mid-Atlantic. Okay, finally, state court litigation. So this is focused on lawsuits just occurring in state court, which generally avail themselves of claims within state constitutions rather than relying on federal statutes or interpretations of the U.S. Constitution. So recently decided state litigation related to LGBTQ people is Cross versus Montana. This is again a Lambda Legal, ACLU, and ACLU of Montana collaboration. It was the challenge to, or is, excuse me, the challenge to healthcare ban, Montana healthcare ban SB 99, which is trying to prohibit healthcare for trans adolescents. It was filed in Montana State Court, alleging violations of Montana state constitutional rights, brought no federal claims. The Montana Supreme Court upheld the preliminary injunction against this bill in November of 2024. And on May 13th, so not that long ago, Montana's 4th Judicial District granted the plaintiff's motion for summary judgment on state constitutional grounds. Some of you may know Montana has a very robust right to privacy in their state constitution. I think it might actually be a right to medical privacy. And so if you're interested in this particular avenue of litigation to challenge some of the anti-LGBT laws that are unfolding across the country, state constitutions and state claims are an emerging successful path to challenging these laws. Notably, the motion for summary judgment ruling it has already been appealed to the state Supreme Court, so there will be more briefing in Cross versus Montana. The next case, which is not a Lambda Legal or ACLU case, it's a case brought by Upper Seven Law, which is a Montana-based progressive nonprofit, and it was a challenge to Montana's state law defining sex as binary. It was filed in Montana State Court, again alleging violations of Montana state constitutional rights of equal protection and privacy. They brought no federal claims, and a motion for summary judgment was granted in early 2025, holding that the law is facially unconstitutional and in violation of Montana's guarantees of equal protection and privacy. As of late May, early June, this decision had not yet been appealed to the Montana Supreme Court, but again, in the last month, that may have changed. Another notable state court challenge, Moe versus Yost, is a ACLU National and ACLU of Ohio challenge to the Ohio state law banning healthcare for trans youth. Again, focused on provisions of the Ohio state constitution. The Court of Appeals reversed and remanded to the district court to enter permanent injunctions for violations of healthcare freedom, of the Healthcare Freedom Amendment and the fundamental right of parents to seek appropriate medical care for their children. It has been appealed to the Ohio Supreme Court, and the state of Ohio secured a stay of the injunction granted in late April. So technically this law is in effect, even though the litigation before the Ohio Supreme Court is ongoing. So a few other state court cases I have listed here in Missouri, 2 in Texas, and 1 in Kansas. Again, these are all regarding state statutory or constitutional protections that are in various procedural postures, but are worth exploring as you review the materials later. And I wanted to identify a couple of helpful resources for people who might be interested in this avenue of litigation, of litigation against or challenging anti-LGBTQ laws. Statecourtreport.org is an incredible resource that tracks litigation of all kinds in state courts. So you can go to that organization's website, and they keep it very up to date, and you can put in your issue area and you can explore cases that are happening in state courts across the country on a particular issue. There's obviously a section there dedicated to LGBTQ cases, and frequently they will do case reports or short articles detailing the posture of those cases and opinions that have been released on various motions. Helpfully, through that website, I also found a state survey and analysis of state constitutions with privacy protections written by Professor Lee. And I've just posted a screen grab of her article that you might want to review. It was published in late January. If you're interested in exploring this particular avenue. And with that, I think we have time for some questions if there are any, Nina.
Absolutely. Thank you, Carl. Before I go ahead and dive into questions, and just a reminder, if you have questions, please submit them by clicking the Q&A button in the control panel at the bottom of your screen. We can now go ahead and dive into some questions. So our first question is from an anonymous attendee. They ask, how are post-Dobbs legal arguments around bodily autonomy and parental rights being used in challenges to gender-affirming care bans?
Great question. So really, much of the work that we are doing on behalf of trans young people and their families challenging healthcare bans are constrained by the Dobbs ruling, right? Which is really limited challenges to the right to bodily autonomy and privacy as it relates to obviously that was about Dobbs is focused on abortion, but the court is using that lens to now look at other arguments about people's right to decide what happens to their body in any kind of medical setting. Parental rights is an argument that we bring essentially in every case where we challenge a gender affirming care ban, because children are the responsibility and are legally represented by their parents. That notably, that question was not answered by the Supreme Court in Scrimeti. So we live to fight another day on that claim. And you'll see that in much of the work that we continue to do, we will continue to bring those cases, given that there still remains a persuasive and binding precedent, not just persuasive, but binding precedent about parents' rights to direct the care of their children. There was some discussion of that in Scrimeti, but that was not the core of the court's ruling.
Thank you, Carl, for that additional insight. Our next question is, so with all of these decisions in mind, what are the legal obligations of public schools towards LGBTQ plus students in jurisdictions that have enacted some anti-trans policies?
Great question. I should have said at the beginning that I can't unfortunately give any legal advice, and nothing I say here today should be construed as legal advice. And the webinar does not create an attorney-client relationship with anyone, but for jurisdictions that have enacted Don't Say Gay or anti-trans policies, I recommend, again, not legal advice, getting involved with local chapters of PFLAG, state equality-based orgs, such as Equality Florida, Georgia Equality here in the Southeast. Your state has an equality org no matter where you are in the country. You may have to look around, but if you go to equalityfederation.org, you can find your state's LGBTQ equality group, and you can figure out what is happening in your state related to addressing Don't Say Gay limitations or anti-trans policies. I would argue that public schools continue to have the obligation to LGBTQ students that they have always had, which are obligations to educate and ensure students' safety. That should be paramount in all of these discussions, right? Even as advocates are taking on anti-trans policies and Don't Say Gay laws, schools have an obligation to keep students safe, to prevent bullying for all students, but particularly for students like LGBTQ young people who we know experienced significantly higher rates of bullying based on who they are.
Thank you, Carl. Our next question has to do with military members and some of the separations that have been happening there. So Logan asks, is there anything to look at to prevent those separations with these new policies in place? How would you recommend staying on top of those developments, or any insights that you may have?
And it is really a tragedy that essentially, as of right now, there is really nothing we can do to prevent those separations. We had a nationwide injunction in place, and because the Supreme Court stated, the military is moving swiftly to separate those people. Now, I know there are people trying to work on this issue. So there are organizations like Sparta and other LGBTQ military service member orgs dedicated to trying to provide support to trans service members who are being separated. Um, but I'm sad to report it's quite bleak right now, and uh, any solution to this problem is going to be years down the road.
Thank you, Carl. We did have Deanna ask about that website that you mentioned. Could you repeat the name of the website that they could go to for some resources about like local policy?
Sure.
Thank you.
Sorry for the sound of my typing, but this came through where holidayfederation.org. They just had their annual conference. So that's where folks from orgs in every state go and meet up and talk about the issues that states are facing, and take insights back with them. So you'll find your state equality org hopefully within that list. And of course, if you don't, please reach out to me and we can talk about other resources.
Thank you, Carl. Our next question, I think we have about time for two more. Our next question is, how are state and professional licensing boards regulating conversion therapy, and what recent court decisions have affected that authority, if any?
Yeah, so that's a great question that I only have a limited answer to. So my general understanding is that conversion therapy prohibitions have generally come through state anti-discrimination laws. So, for example, I think that Colorado is one of the, one of the more than 10 states that have limitations on conversion therapy of licensed practitioners, right? And the argument in Trials versus Salazar is, I think, does have a free speech component to it, right? Is conversion therapy conduct, or is it free speech, or is it speech rather? And so the 10th Circuit said it was conduct, which could then be limited by state law prohibitions. But it's a good question about what state licensing boards have done to limit the practice of conversion therapy. My general answer, getting back around to the question, is probably not a whole lot. But it's worth looking into if you are or know or represent folks, mental health care professionals, right? If you're involved with folks who are licensed clinical social workers or psychotherapists. I know the APA, the American Psychological Association, and other mental health national orgs have come out against the practice of conversion therapy, but I don't know if that has trickled down to state licensing board requirements.
Understood. Thank you, Carl. Our next question is, how should employers navigate Title VII protections for LGBTQ plus employees amid this evolving landscape?
So the one thing I didn't get to talk about today is that Bostock is still good law. And of course, that is the 2020 decision from the Supreme Court holding that discrimination on the basis of sex in Title VII means sexual orientation and gender identity, right? So LGBTQ employees cannot be discriminated against on the basis of sex as it is understood in Title VII. And, despite the administration's attempts to dismiss or ignore Bostock and its implications, it remains good law. And so I think that, employers should be thinking about ways that they can adhere their policies and practices to the letter of Bostock, right? And to subsequent decisions interpreting Bostock in their jurisdiction, right? So you're obviously going to want to think about how has the circuit court that oversees my state, or district courts in my state, interpreted Bostock, right? And in most cases that I'm aware of, the protections remain very solid. Now, I do want to mention as a caveat that in the first few weeks of the new Trump administration, there was some turnover at the EEOC, right? That's the Equal Employment Opportunity Commission. Some people were removed very publicly with a lot of protest and public announcement. And for a time, the EEOC was saying that they were not going to process charges of discrimination that were coming to them on the basis of sexual orientation or gender identity. I want to be very clear that is in direct violation of their statutory obligations under Title VII. It took them a little while to get there, but a couple of weeks ago, the Washington Post reported that the EEOC has now said they actually are going to correctly process claims brought by LGBTQ employees for discrimination. Now, they've made a few caveats, right? They are continuing to adhere to their interpretation of Bostock that is only about hiring and firing. Bostock is not so limited, right? And neither is, more importantly, neither is Title VII. So employers should continue to adhere to the decision in Bostock and support LGBTQ employees with policies that protect them from discrimination, ensure that they have access to the same rights and benefits as other employees, and consider ways that workplace policies might be inequitable, right? Might favor a majority group or not consider the specific needs of LGBTQ employees.
Awesome. Thank you so much, Carl, for your presentation today, your insights, and answering all of our audience questions. We really appreciate it. And thank you all so much for submitting your questions. We deeply appreciate your participation. We want to thank you all for joining us for another Justia webinar. Before you go, don't forget that Justia Connect Pro gives you access to CLE credit opportunities through live and select on-demand webinars just like this one, so you can stay informed and compliant. Plus, Pro members enjoy an enhanced profile, AI-powered Justia chat, and exclusive discounts on Justia marketing solutions. To learn more, you can go to pro.justia.com. Have a wonderful rest of your day, and thank you all for joining. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.